ओके, क्लाउड शो कर रहा है तो मतलब क्लाउड रिकॉर्डिंग है क्या ये?
हाँ,
Today we are presenting this online workshop on research skills in litigation. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the question box in your Zoom control panel. I'll bring them up during the presentation, and we'll also have the time for questions at the end. Now, without further ado, we will turn the time over to our speakers. Our presenters for today are Dr. Malika Gautam and Mr. Vishavjeet Chaudhary. Dr. Malika Gautam is a practicing advocate in the Supreme Court of India and counsel at International Court of Justice, The Hague. She is an academician dealing with various topics of law and visiting assistant professor in Manav Rachna International University, along with KR Mangalam University in Delhi NCR. She is the head of Women's Cell of YUVA, an NGO which works for the furtherance of women's rights and education of underprivileged children. Coming towards Mr. Vishavjeet Chaudhary, he is a Delhi-based advocate, having done masters from University of Cambridge. He is qualified barrister and is a door tenant at a London-based set. His areas of expertise include constitutional law, criminal law, and human rights. He has extensive experience in advocacy, writing, and research. Now I am handing over the platform to Dr. Gautam first, and then we'll be moving forward with Mr. Vishavjeet. Ma'am, the stage is all yours.
Yeah. Thank you so much. I will just start by saying this, that legal research is a very, very important tool for individual lawyers as well as law firms, irrespective of their practice areas. And therefore, I feel that the identification of the right issue is done and promotion of effective research is done due to legal research. Good research involves searching for underlying principles for finding, understanding, and applying the law. Legal research and its importance, its benefits are in the legal industry and they are very well known. It involves basic search for landmark cases governing the issues in question. Legal research, though sounds a simple job, but I assure you it's not. The legal skill to conduct research is indispensable for lawyers, regardless of the area or type of practice. Legal research helps in appreciation of moral and social values, but it is very time consuming and very exhausting task. There are some common problems that I feel that researchers face while doing research. First and foremost, there is a very strong possibility that while you're doing the research, the issues at stake are wrongly interpreted. And wrong interpretation can result in research not being relevant to the current issue, and therefore it can be completely pointless. Hence, the identification of the right issue is very crucial for an effective research. A good research involves searching for underlying principles of finding, understanding, and applying the law, like I had mentioned before as well. The second issue which I feel that the researchers continuously face is changes made in the law of a particular state or a country. Split and conflicting decisions also make it difficult for legal researchers to reach an appropriate conclusion. In many citations that I've myself used domestically, I've realized they cannot be used internationally, and that leads to a lot of confusion and a lot of complication. The most significant stage for legal research begins with the beginning of a case, is what I feel. It is important to carefully explore the facts. It is important to understand the legal doctrines and the examples that may apply. This shapes the strategy for presenting a good case. And basically, what I mean to say is that legal research is basically the foundation of your case. Whatever you are doing, it starts with the legal research. A lawyer's understanding and analysis of the case starts by identifying the relevant facts and determining the legal issues that need to be researched. Now, this analysis continues the question of what needs to be researched and what needs to be determined. As relevant legal matter is found, application and understanding, both are very important. The legal research makes available a crucial investigative base, and that prompts the decisions for the rest of the case. Like I said, it's a foundation for anything that you do. However, one should not forget that right conclusion depends upon the researcher's ability. And for them to analyze and fully understand the matter found during the research process. Research needs to be taken seriously, and one needs to be committed to continuously develop their researching skill. Even after 10 years, after 20 years, one needs to be at top of their game. They need to continuously and consciously keep working on their research skills. One should be up to date with frequently changing laws and should be able to devote long hours to understanding and keeping with it. Looking for the correct issue can be time consuming, and I have seen so many people use the wrong judgment with the wrong uh, sort of point because they are not very clear on the topic as to what they have to say, and it becomes very confusing even for the bench when they are trying to understand what the lawyer hasn't understood. Now, patience and a yearning to learn are the qualities that all researchers must possess, as research skills enables one to learn about new areas of the law and keep up to date throughout their career. Researchers' ignorance about current or the changed law is no excuse, and one should not think this way that a list of resources should be provided or anything. One should be very prepared as to what to research. A person undertaking legal research project should be knowledgeable of the fundamental principles and issues of law related to the topic of research undertaken. Thorough knowledge will help in determining on what issues and facts are significant. Though there are many tools available for the conducting of an effective research, legal research has become very difficult as the need for the accurate and current data has emerged, and thus asking the researchers to acquire new skills to keep pace with the changes is important. Research is a critical skill which all practicing lawyers must acquire, though nowadays attorneys who are hard pressed for time cannot devote time and they're outsourcing such projects. And there are things like legal support service providers which are based in India, or for overseas also, people outsource it to India. All of that is happening. But however the case may be, the benefit of outsourcing these projects does save on costs, but the time and the delivery of these things is exactly the same as the offshore vendors support a team of well qualified lawyers. It's basically interns and legal researchers. All of those people are actually doing these offshore support teams. Now, what is important is that how one must conduct legal research. Now, there is no definite methodology or a set pattern to conduct legal research, and each lawyer devises their own method as and when what is suitable to them. Some lawyers prefer traditional ways of conducting legal research, as do I. I mean, I like to read up on Judgment Today and All India Reporter, or digests or manuals, or there are Supreme Court cases, or there is the scale or stuff like that. So I like to keep up with the old things. I am traditional in my research, but there are some lawyers who rely heavily on the legal software, such as the SCC Online or the Manupatra. I'm sure students as well as lawyers have used this at some point or the other. So have I. But with digitization, I feel like there has been a huge impact on the legal research domain. Like for lawyers, the development in the field of information technology has truly been a boon. But there is yet to be there's a huge thing that it leaves a gap for. Now, there are software for lawyers that allow them to conduct legal research in minutes. You will go in Supreme Court libraries, or you might go in other tribunals. There are libraries which have these softwares which make you, search from all over the web, and you find a lot of judgments. But it's not very effective because once the software crashes, you have to rely on the traditional method of researching. And a lot of people don't learn how to traditionally research just because they think that there is a digital method available. So that is a problem that I feel is with digitization. One must know the traditional way as well. Now, there are various legal databases that filter out types of cases and citations and enactments and all of that. So that is a good point. I feel like they are helpful as well, because if you're going through in a book, if you're finding it in the Supreme Court cases or the AIR, you have to, go through the whole thing, and you have to research the whole thing, and you can't really filter out certain things that you may want to. But as far as the databases are concerned, it is easier to work in the online citation. Now, there are case management tools that enable lawyers to manage their cases in a single place, access all case related documents, manage cases online. And there's this whole cloud based system, and they can conduct legal research in seconds because of the digitization. But there are various interrelated reasons why lawyers need software for legal research and case management. And that is the entire essence of being a lawyer. The need to be conversant with the main ingredients of a case. A lawyer can only be conversant with the following ingredients if he or she conducts extensive legal research regarding them. Even with the facts, a legal research can only help with the background of the case, but you have to research upon a certain fact, a certain, otherwise you can't, determine any fallacy. Now, point of law in disputed issues. Now, the point of law can easily be found by legal research, browsing through the primary and secondary sources of information. Cases, statutes, regulations comprise of the point of law and may also extend and include precedents or earlier judicial decisions which may be persuasive or even of authoritative value. Now, when you come to the arguments, there are a lot of lines of logical argumentation used in earlier cases and can be found and replicated in cases of a like kind. Also, new grounds for argumentation can be found in some long lost statute, code, regulation, etc. After close analysis, research can lay down and his client. Evidence points substantiate all the cases, and all these things are very important. Now, online software for lawyers and e-discovery tools based on predictive analysis enable lawyers to manage the evidence in a case of minutes. Like I said earlier, it is very easy with online research. It supplements the area of practice, adds value to the area of practice by backing up whatever is being quoted from different credible sources. Complete knowledge about issue when a matter comes to court is very obviously, it is presumed that the lawyer representing the interests of a particular party is supposed to comprehensively have answers to every question that is put up to them. Whether it is a question of fact or a law or anything, the lawyer has to have knowledge. Otherwise, it will reflect poorly on him, and therefore, research is important. Now, in any case, it is not the work of the judge to point out which legal provision should be applied where, and it is the job of the lawyer, and it is his duty to inform the court about all the provisions that could be applied. And good legal research can land up with not only a good and binding authoritative cases, but also it helps in a lawyer having a persuasive value, and they are able to persuade the bench better, and then eventually win. But yeah, on close analysis by lawyers, they can extract out underlying principles of any case, judgment, statement, anything, by a public figure if there's a statement. This can happen if concrete legal research has been done. World happenings, particularly relating to the stand taken by different countries. Now, this is for international law. Like if there is something, if there is a big event happening, for that different countries need to know this, and there has to be a legislative history and historical events. Everyone has to have that knowledge as well, because if you don't have that knowledge, you will be obviously caught on the wrong foot. And a lawyer must make use of this to indicate the enforcement of a provision, since it is acceptable in the international domain. Domestically as well, I feel that we can determine the nature of our law by considering the trend of our legislative history. A person undertaking a legal research project should be knowledgeable of the fundamental principles and issues of law related to the topic of the research. Thorough knowledge will help in determining the law on significant issues and facts. The advantages of legal research are the lawyer's understanding and analysis of a case. This often begins in the research state when they identify the relevant and determines the legal issues that may be researched. Another advantage of legal research in this analysis continues as is refined as they decide where, how, and what to search. They find it seemingly relevant that there has to be a relevant legal material. They must understand all of that legal material and how they have to apply that legal material. And they also have to know how to apply that particular legal material to their case and the facts of their case. Now, this research has to provide a crucial analytical foundation which informs their decision for the remainder of the case, not just the facts, but the rest of their case as well. Now, there can be various legal sources. The research can have various sources. The primary sources, the rule of law that is binding upon courts, governments, individuals, constitutions, statutes, regulations, treaties, and court orders. These are some examples of how primary sources of authorities work. Then there is persuasive primary source, which are like the commentaries on the law, and they don't have a binding effect, but they aid in explaining what a law should be, right? It's like examples of that could be a primary authority which is not binding on court, just say I think the opinions of judges or attorney generals or a law minister or a ministry of parliamentary affairs. Anybody. This basically includes an opinion which may or may not be binding on the court, but it would be persuasive, as it would persuade the court to make a decision in a certain manner. Now, then there is the secondary source, and that could be law generals, periodicals, articles, textbooks, legal encyclopedias, dictionaries, annotations, opinions, and surveys, all of that. Now, research is considered to be more objective, methodical, and well determined. Though research, a decision maker can quickly get summary of the current scenario, which improves his or her information based for making sound decisions and effective future operations of organizations. It is very useful to accelerate the decision making power, and it alone can make it possible for the identification of the determinants. The key to success in researching legal issues is realizing that the research is a process, right? You cannot memorize a million cases, and you're not looking for a needle in a haystack. You can't do that. Your brain is not a database. You can't remember unlimited judgments, but you can master overall process of research. You can understand how one needs to conduct research. And as a lawyer, you need to base your analysis on the law and the judicial opinions, as well as statutes and constitutions and administrative law. Legal research will be unlike any research you have previously done, because it requires you to use legal analysis. And this analysis will tell you which issues to research, how to use the resources, how to use answers to your client's problem. Without understanding this, you may be able to perform the mechanical functions of the research, but you won't be able to understand the results of the research. And another unique aspect that I feel is that often there is no clear answer to the question you're researching. Instead, you will find like small pieces to a puzzle, and you will have to use your brain and your legal analysis to fit those pieces together. So it's like a puzzle. You don't get the answer flat out. And there's no magic to it. It's just an interwoven process of research. And when you know how to research, and you know how to analyze, and you know how to write, that's the quality that makes you a lawyer. That's my opinion on legal research. I'm sorry, I can't hear you.
Siddharth, kindly unmute yourself.
Yes, ma'am. So, ma'am, my question was, how can we find a right law to apply onto a given issue if the issue is vague and someone is not able to find a right law, and there are various law upon an issue? So, which law is to be applied, ma'am? This is the question.
See, what I feel is that you don't know. This is my experience. I'm not saying this is the right answer or anything. This is how I have functioned in the legal field. I feel like there is no right judgment or a right law. It's just how you fit a judgment or a law according to the facts of your case, right? It's very, very subjective. I don't feel that any judgment is wrong or any judgment is right. You need to have the skill to fit that judgment in your facts, in your case. So that is important.
Okay, ma'am. And the next question someone asked, uh, how good research skills help you to hone your advocacy skills?
See, I feel like it is very important that research skills for a lawyer is the most important. I mean, apart from obviously you need to know how to draft, you need to know how to plead. But if you don't know where what will go, if you don't know how to research a particular topic, or if you don't know how to research a judgment, I think it's pretty much a waste of your legal skills if you don't know how to research. So I believe that it is important to know that. It's very important.
Ma'am, I too face the problem that what should one's strategy while finding a relevant case for litigation or even for moots?
Hmm.
How can we find a relevant case? Ma'am, like there are various cases that were overruled and there is no new case. So how can we find a case that can be binding?
See, what I believe is that one needs to be very, very up to date with certain things, especially the law, and especially the law of your land. Because if you don't know what you're looking for example, if you think that, okay, so let's just get out of the legal aspect for a second and just let's take a random example. So you go to a market, right? You go to a market and you know that you are going there to buy mangoes, right? You go and purchase mangoes, and you know that you have to purchase mangoes. So you know what you're looking for, right? But in case you don't know what you're looking for, you just go to the market completely baffled. You don't know what you want, but you just know that you want to purchase something. That's exactly the case with legal research. You need to know what you're looking for. And at a certain point, you need to understand the point that you're researching. If you don't understand that, all of your research is pointless, is what I'm trying to say. So, in order to understand the whole research part of it, you need to first understand the facts of your case and the facts of your moot, even if you're the memorial that you get, you need to understand all of that.
Ma'am, someone has asked the question, what
Hmm.
do we mean by authentic resources in research? Ma'am, this is the problem we face sometimes.
Right.
Like someone says, I've seen it on Wikipedia, I've seen it on Facebook. So what are some authentic resources in the research for a lawyer and a law student?
See, for a lawyer, we all know that we research searching these I told you scale, we go through scales and law journals, and there are so many all India reporter, SCC, all of that. But even digitally you have so much to research from. There are so many platforms that are available. I use SCC online and Manupatra, since they are accepted in the court, but there are a lot of these programs that are not accepted by the court that a lot of you might know about, such as Indian Qanun. Nobody really accepts that. Not your colleges, not even the courts. They don't accept those. But that does not mean that they are not authentic, because I feel that one can learn from wherever they want. It's not just that you have to find a certain thing from a certain place. One can gain knowledge from any place whatsoever, is what I feel.
So it looks like we have covered various questions. So now I would like to call upon Mr. Vishavjeet Chaudhary to come on the platform and share his views.
Hi, can you all hear
Sir,
me?
please.
Can you hear me? Can you see me? Are we set?
Yes, sir.
Excellent. Well, first of all,
Yes, sir.
I'd
Yes,
like
sir.
to I'd like to thank the charter and everybody who's organized this talk. I think it's imperative that we do talk of research. And thanks also, big thanks, in fact, to Dr. Gautam, who's pretty much made my job as easy and as breezy as it could get, because she, I think, brilliantly covered many of the things that I wanted to say. So I just wanted to add a few other things, and some things might be a repeat of what Dr. Gautam has already brilliantly put. But the first thing is, I mean, the thought of research. Now, at least from my experience, and I am currently litigating and practicing, but prior to that, I've also worn another hat, which is that of a professor at General Law School. And one of the things that every first year probably says is, why did you join law school? Now, there are two kinds of answers to that. One is a doctored one, which is I've joined law school because I want to go in the path of justice and I want to change the world. And the second one, which is slightly less usual, but I think more honest, is because I watch Suits, or I watch Silk, or I watched, Kevin QC, and I just want to be like a lawyer, like they show them on those shows. And the second one seems to be, across the board, one of the reasons why many people become lawyers. But sadly or not, I think taking political license, I've never seen a Suit episode where, for instance, they've shown how much research is is carried out behind the scenes, and they only show the cool looking things which students inevitably think that they'll be going through the gown, going through the Supreme Court, yes, with the gown flying, and then somebody's going to picture them and ask them questions. But I'll tell you another thing: research is probably more important. So what you see and what you perceive, and what many, in fact, first year law students perceive to be the law, is only the tip of the iceberg. The real thing that is below is what's most important. And when I was training for the bar, we had different people come in. There were a number of Queen's counsels, number of senior counsels who came and trained us. And rather interestingly, there were also people from RADA, which is the Royal Academy of Dramatic Arts. And they gave us an analogy which I've never been able to forget. And one part of that analogy was that when you are a lawyer, you're like the swan. If you've ever seen a swan, very elegant, sort of just floating on the river. But if you were to simply peep under the water, the feet are always struggling to just stay afloat. So regardless of how much struggle there is in research, nobody really seems to be talking of that. And the second analogy was that this also answers one of the questions that you asked about linking facts to the law. And one of the analogies is that you think of the facts as coffee beans, and you think of the law as a coffee machine grinder, and you see how it goes through the grinder. So each fact that you've got should go through that particular law, and then you come to a conclusion. So there are about 5 or 6 things that I wanted to say. The first is, of course, the importance of research. I'm not going to waste any time of that. I think Dr. Gautam's done a brilliant job of telling you all why it is important. So what is to be taken away from what I've said so far? The most important thing is that research is just as important, if not more, than advocacy, right? Because if you've got brilliant advocacy skills, you still need good research skills. The good news is that they can be developed. It's not an inborn trait in any manner whatsoever. It can be taught, it can be learned very, very easily. There are 2 things about research that are very, very interesting. And one of them is that it's an evolving thing, right? Because new pieces of information and new pieces of law keep coming. And the second one is that it also is open to interpretation, which is, again, very, very interesting. So you need to be constantly researching. I've seen lawyers in their 80s, even in their 90s, who every morning would read the law, and then they'll fish out a case from 1967. In fact, this actually happened in a case where the counsel on the other side was in his 90s, and then he fished out a case from 1967, which his father had prepared. And then he said, well, I had never come across this case before, but it's been unearthed today, and that changed the course of law. So there are 7 things that I wanted to talk about research. The first one is that it needs to be absolutely thorough. You need to be completely clear about what your resources are. As Professor Gautam said, you can't be using Indian Qanun. One thing that I've noticed is that Indian Qanun is an open source. Many students do prefer it, but please, as early as you possibly can, I'm sure your colleges do subscribe to Manupatra, SCC Online, and the Westlaw, LexisNexis. These are really the resources that you should start using, because you definitely will be using those when you get into practice. The other thing is you must also be clear about a primary source and a secondary source. Don't think that a judgment can't be a secondary source. A judgment can also be a secondary source. For instance, if it's talking about another judgment, that it is interpreting in its own way, right? So if it goes, for instance, if it's a 3-judge bench and if it goes to a 5-judge bench, it can be interpreted in a completely different way. So please be aware of that. Also make sure that your resources that you use are authoritative. In terms of books, of course, are very, very good. But make sure any resources, and trust me, I've seen this happen. Just to create a bit more ambiguity, I've also been visiting faculty at NLS Bangalore, and I've actually seen people quote sources like apunkalaw.com, spongeboblaw.com. Please don't do that, because they're completely unauthoritative. There's absolutely no value to them. Make sure you're also clear about what is a binding source and what is only of precedential value, which I think Dr. Gautam did talk about. The third thing is the chronology and the dates. Make sure you know which case is from where. Some years ago, about 2 or 3 years ago, I was working with the counsel, and my researcher, he found a case which I forwarded to the counsel, and it turned out that the case had been overruled, and only I know the sort of, and quite rightly so, the sort of anger that was expressed towards me. Please, please, please make sure that you know when the case is from. Whenever you're presenting in class or whenever you're looking at cases, the name is not as important as the year is, because the year really tells you two things. The first one is what value it has today. And the second, which I find more interesting, it also tells you about the political and the social economic conditions of the country at that particular time. And that is, you can then trace the sort of reasoning of the Supreme Court and the trend that the courts are following in those particular years. The fourth one, which I started a little bit too late in my career, but I would advise that you guys start the day you start law school, is to maintain a diary of your research. Whenever you're researching, now there are different ways of organizing it. A lot of the people now that I know use electronic sources, and it's easier to do it online. There's a source called Evernote. I know many people use it. Just by full disclaimer, I'm not their ambassador. I don't use it. I'm not being paid for that. But you could look up Evernote, and there are a number of other programs which you could use. I still stick to the old register diary format, where any case that you do and all the cases that you've researched for, you put them in an index, and then you have them ready when you are going to be using them, because you don't know what you're researching today and what could be useful tomorrow. So make sure you maintain a diary. How you organize it is entirely up to you. One way to do it is to divide it, roughly speaking, by subject type. So for instance, you could have civil law, criminal law, public law, private law, whatever you wanted to do. The other is to divide it topic-wise. For instance, charge sheet, all the cases that you've researched on, just a line or two about what the fundamentals of the case were about. The fifth thing that I'd like to say about research is please be open-minded. There have been instances where people have given me brilliant cases which would support their point. But the thing that they've missed is that there are other cases that go into the teeth of, that hit on the teeth of the cases that they've given me. So please make sure that you do carry out a balanced research. We are in an adversarial system. It's imperative that you acknowledge that and make sure that you get research both for your proposition, but also against your proposition. Because if you've got against your proposition, then it's a much better strategy where you can use at least part of it to dent the other side's claim. So make sure you're doing that. Number 6 is all the things at some level are related. They say how many ever degrees of separation, one way or the other. This is another analogy which my professor gave me, and my senior, in fact, she is a QC. She gave me was that law is like knitting a sock. I don't know how many of you knit, but if you ever did knit, and she actually did demonstrate it in class, sock, you start at point A, you knit the entire thing, and then you come back at point A. So law in many ways is like that. Many things will come back to the basics. So make sure you are able to draw the lines. Number 7, which I'm sure you've sort of heard ever since you were little children, is there's no substitute for hard work. You do have to hard work. You do have to work hard, but the prize is that by the end of it, I can assure you that it becomes a lot less painful. And dare I say, it sometimes even becomes interesting when you've just cracked that particular case or that particular material. How, in particular, to do research is, as again Dr. Gautam said, it's completely dependent on a number of factors, including how you work. For me, uh, I know a lot of other people like to do the same thing. For me, what I like to do is I like to find what the problem is. Something which I'm not sure what year of law school you are all in, but you'll at some point you'll encounter this term called facts in issue, which means what are the main things that are being disputed in that particular case. You will have to make sure that you are completely, you hit the bull's eye when you talk about the facts in issue, because that's really where the beauty of the case is, and that's really what will be the deciding factor of that case. Get that first, then you tie it in with the facts, and then there are different ways of doing it. I like linking it to different things. Don't underestimate the power of Google, because I know many a counsel, they would start their research on Google, and once they find the number of cases, then you go and read the entire case. Make sure you read the entire case. There have been instances where, for instance, many people have given me the entire judgment, except that they've missed that one fine line at the bottom, which is all of the above has been overruled. So make sure you read the entire case and get it to the bottom. There were a few questions which I was asked to address. The first one was about the importance of precedent. Now, precedents are an interesting thing. And if you look at the Supreme Court history, and if you look at the world history of how they've worked, you must take them with a pinch of salt, because each case would turn on their individual facts. There will be some precedents which will be binding, but it's not to say that precedents are a line on the rock. For instance, we've seen in the privacy judgment, we've seen in a number of other judgments where previous cases have been overruled by bigger benches. They can be differentiated, they can be overruled. The good thing about precedent is that they give you at least some form of certainty, but that's not to say that you take them at their face value. Make sure, even if the precedent is supporting you, you are able to differentiate the case, at least on some things. For instance, there might be completely different factual matrix in the previous cases. The second thing which I've encountered a lot is about what do we do if the judgment is too big. I wish I could give you a simple answer to that. There's really none. I wish I could just tell you, you put it on your head, or uh, raise it and then swing it around your head, and then it'll be clearer. There's really nothing that I could help you. However, there are some tactics, and this honestly is a trial error and trial method. Once you start doing, once you start litigating, or once you start reading a huge volume of cases, you do get the feel of where the keywords are coming. Please read it. During your school time, law school time, I'd recommend that you read as much as you possibly can, because that also increases your speed of reading. As far as big judgments are concerned, please don't take it at face value. This is just one of the tips that I use at work. Sometimes it doesn't. For very, very long judgments, usually the first few paragraphs and the last few paragraphs are where the meat is. But if you remember, there are a number of judgments where, for instance, including the media people who, many of them have legal degrees, and there are a number of cases where they've reported completely wrongly that the Supreme Court overturned it. The Supreme Court didn't overturn it, because there were 5 judges, 3 of them concurred, 2 of them said the other way, and they were given in different orders. So that you have to be very, very careful about. But for long judgments, one of the tips is the beginning and the end. The second thing is, don't undervalue the importance of text books. Because some of the textbooks are really, really good. You've got Pakwani, for instance, for CPC, R&D for CRPC, again, D.V. Basu for constitutional law. Again, I'm not getting any money out of any of the sales of these books, but I would recommend that you read them and familiarize yourselves with them. Sometimes it's easier to go and find the secondary source in the book, and then go back to the case and then look at what is happening. The third thing that I was asked to address was the tactics that you would use in terms of research. One is, of course, resources that we've already discussed. Use your time to hone your skills, especially on Westlaw, LexisNexis, Manupatra, SCC Online, when you're in the law schools, because this is really, time when you can experiment. You can't do this in court. You can't be experimenting there. But in law school, you really can. And something I used to tell when I used to teach all my students was, you must have heard that there's no such thing as a stupid question. I disagree. I think there is a thing as a stupid question. But law school really is the place for all of you to be asking those questions. I'd much rather that my students ask those in the law school, in the safe compounds of the law school, rather than when they are standing either in the High Court or the Supreme Court or wherever, and then asking those questions. So experiment in law school as much as you possibly can. Please don't quote me to any of your professors when you give them shoddy pieces of work. Experimenting does not mean shoddy pieces of work. It just means trying different approaches till you hit the target. The next thing that I was asked was about Indian litigations abroad. Now, I would say that litigation is really about skills. Law school is about skills. Trust me, any cases that you do currently, any cases that you read currently, by the time you guys are into practice, they would have become redundant. In fact, many of the statutes are so quickly changing that many of them would have become redundant. But what will remain and what should remain is your ability to find out research, find out different areas, and be able to comprehensively and constructively look at what the law is then. So regardless of whether you're in India or you are outside the country, it doesn't matter. Your skills will always help you. Again, as Dr. Gautam rightly pointed out, the difference between precedential value and binding value, that of course is the Indian cases will not be binding outside, and vice versa. So that is there. Also, keep in mind that there are different systems of law: the civil law, the inquisitorial law, versus the adversarial and the common law. So the importance of cases, for instance, is a lot more in common law, which is a system that is adopted by most of the Commonwealth countries. So that is your answer to that. Now, I just wanted to say, as a closing remark, that research is really as much science as it is skill. And one thing that I always say and find absolutely fascinating, and I think Jonathan Bild is one person. He's not a lawyer. He's into English literature, and I think non-lawyers can be as interesting as lawyers, if not more. So he has said something very, very telling, which I find very fascinating. And he said that, look, if gravity had not been quote unquote discovered by Newton, would we have discovered gravity? And the answer is probably yes. It's not like apples don't fall off trees and pens don't fall off. So we would have eventually discovered it. Maybe it would have taken some time, which is not to take away from Newton's brilliance. Of course, he was brilliant, but we would have discovered it. However, think of any piece of literature. Had Milton not written Paradise Lost and Paradise Found, would we have discovered it? Maybe we would have discovered the theme, but not the exact language and the exact prose that we've given. So my advice to you is that you guys are not only discovering gravity, but you're also discovering paradise. And you must be proud of the work that you put on in your assignments, as well as in your opinions when you are going into court. Be brave, have the courage to experiment, have the decency to explore all the possible options, and go discover gravity and paradise. Thank you.
So there are some live questions. So the first one being, if you can suggest any particular books referred by lawyers or such authors, if you could recommend that you use yourself.
I think there are a number of books, but I would say read as much as you possibly can. One book that I would recommend, I think that should be compulsory reading in all law schools, and I'm not sure if Dr. Gautam would agree with me, probably she would, is Learning the Law by Dr. Glanville Williams. That's really all you need to know before you start law school. He's really made it very, very easy. Now, be careful that there are a number of pages on the European Union. I mean, the European Union idea in itself is, some might say redundant. So especially for Indian students, you don't need to know what directives are, what any of those are. But the book, in terms of its principles, is really, really good. I would also recommend that you expand your book library to other things. For instance, things like Roses in December is another classic that I constantly keep on reading and rereading. So those are some of the things that Mr. Nariman's books, these are all things that you should be picking up.
So next question is, what are some mistakes which must be omitted while researching for a beginner?
Right. The first mistake I think I've emphasized enough is your sources. Please make sure that the sources are authoritative. No Indian Qanun, none of the other dodgy websites. I'm feeling slightly scared now. I might get a notice from apunkalaw.com, but we'll see. But make sure, please use resources that are authoritative. Number one. Number two, have a deep and clear understanding of what a primary and a secondary resource is. It's really not that hard. Primary resources where the information originally comes from. Secondary sources which either paraphrases or put it anywhere else. That's number two. The third thing, again, very, very important, and that happens especially in a number of law schools. I'm not saying that happens in yours or that you are doing it, but make sure you don't plagiarize anything that you use, anything that you put in. And that's a very important thing, that it's whenever you take anything from a number of sources, make sure that you paraphrase it and you give the citations for that. So those are the three things that I would say, three mistakes to avoid right in the beginning.
As we have learned, there are various type of research, such as the funnel technique. So, is there any particular format of research, or what are some techniques which are best to use while researching a legal issue?
I mean, I use a mixture of the Socratic method. It's not exactly that. So Socratic method essentially is you ask questions and then you get answers to them. So you find out what the facts and issue are. What is it that you need to prove? Make a list of all those things, and then you research authorities for each one of them. The other thing that you probably should also be doing is whenever you find the authority, because there will be times when you will just not find any authority which sides with you. Find close enough authorities. Go look outside of the country. The Indian Supreme Court in the 80s, 70s, 80s, they're very welcoming of looking at, because our jurisprudence was less developed than countries that had been doing it for longer. They're very keen on looking at what, for instance, the Privy Council was doing, or what, for instance, the House of Lords was doing. Now, not so much, but those are some of the things that you can, again, fall back on.
So there is a question from Rhythm. So how to read long judgments, like 1,000+ pages and something like that. So how to read them, how to extract the ratio?
Well, I mean, as I said, sometimes you'll be lucky that the first few paragraphs and the last few paragraphs will give you what the ratio is. But honestly, it's just something that comes with time, where you'll have to tease out exactly what the judges are trying to say. And that's a skill that'll come with time. But initially, I'm not saying do that instead of reading the judgment. But if you're really, really pressed for time, then sometimes use secondary sources, for instance, authoritative books, where somebody's written about that judgment, authoritative journal articles where somebody's written about the judgment. But there's really no substitute to, just sitting on a table, brewing a nice cup of tea and reading that judgment from start to finish, because you'll really only be able to tease out the nuances there. But the more you read, the quicker you get.
There's a question for Dr. Gautam. Ma'am, what is the importance of writing a research paper for a law student?
See, for a law student, I feel it is very, very beneficial, because you get to learn a lot. Because while you're researching for a research paper, if you're able to retain any of that information, you obviously learn. That's what my opinion is. But see, nowadays there are so many. I had an intern a few months back, and she told me that she used to write all these research papers and she used to get those published. But I also got to know that she used to pay money for it. Right. So if you're paying money in order to, getting your, if you're getting your research papers published while paying for those, I believe that you're not that qualified that you need to pay money. But if you're doing a research paper just to educate yourself and better yourself, I feel it's beneficial. Yes.
So what are your opinions on this question? So what is the importance of writing a research paper for a law student?
Uh, well, there are two or three things. The first thing is that, which is my general belief, is that education and especially legal education is really becoming the preserve of a few. And I think it's really for the students, for instance, what you're doing at the charter, etc. These sort of things really need to happen where you make law more accessible. And that initially was the point of a number of research papers. But I absolutely agree with Dr. Gautam. If they're asking you for money, instead they should be paying you, right? Because it's your work, you've done, you've put in the hours, you've put in your research. If they're asking you money to publish it, be wary of those journals. There are only a few journals which are of good quality. Make sure you're publishing it in a good journal. Don't be desperate to publish it. Also, a lot of research is it's simply saying and paraphrasing what already has been done. So make sure that you keep in mind that what you're writing is original, and it also adds to the jurisprudence. May I just suggest that a lot of you, especially in the law school, a lot of people are, if I may use the word, obsessed with publishing in research papers. I would say that look beyond research papers. There are a number of sources, there are a number of websites, there are a number of blog posts, and of course newspapers, which would allow you to publish even small pieces, but those would have the impact which maybe a research paper might not have. So researching is extremely important, and it's also important from a point of view of litigation, because at the end of the day, you're just developing your skills, which you will be able to use when you are practicing as lawyers. So absolutely essential, but don't be desperate to be paying it. That's a rule of thumb. There might be some journals, although I can't think of any, which would actually charge to publish.
So there are a lot already research done on various topics. Can you please suggest upcoming law fields in which research are necessary? So this is a live question.
Well, I would say contempt is one that we are seeing happen in the Supreme Court. So that's one important topic of research. I think it'll be interesting. In fact, I was thinking that it'll be interesting to just trace all the contempt cases that have happened and see, sort of graph of what is happening. Privacy is another one that never seems to die. But I think there are a lot niche topics as well. My area is mostly crime, so I can tell you there's a recent committee which has been formed to give their recommendations on reforms in criminal law. That's another area which
If I may add, there is also the draft EIA that a lot of people are not aware of, and my area is actually environment law, so I keep up with what is going on. So I believe that a lot of people need to understand what the draft EIA is all about. People I've seen don't know about stuff, and they're blindly agreeing. Now this will turn very political very fast, so I'm going to refrain myself. But this is what it is. This is how it is. People are afraid of speaking nowadays. Dissent is dangerous, I feel. So I'm just going to leave it at that.
So a few more questions, then we'll be binding up. So there's a question. So when we are conducting research, what are the clue points that are necessary that to mention in the research? What are some points that we must mention in our research?
What do you mean mention in your research in terms of, for instance, I think one of the important ones would be your sources, whether it's for academic research or if it's for even court, because even court, you can't just say case X, this is what they said. They'll ask you, okay, give us a citation. What year was it? Who was the judge? Calm down. So those sort of things are very, very important. So whenever you do write, research, make sure you have that. The other information is probably, again, this is something for your diary, is the heading of what area you're researching in, where that fits in, and maybe a line of what that leads you to. Okay.
So there's a question for both of you. So someone has asked, what has to do what we have to do in internships? Where can we do internships, be it online or offline, or with some special reference that are related to research or legal research?
Okay, so I feel, and this is mostly because of the lockdown, I feel that online researches don't, online internships don't really bring you any good. This is my opinion. I know a lot of people are very active with online researches. They're very active with the fact that um, they're very active with the submissions aspect of things, but I feel that until and unless you are physically present inside the courtroom, you cannot learn how to function. You don't, because when you're in the law school, you really don't learn how to be practical, right? You learn the theory, you learn how things work, you know all of that, but you don't really know until you're actually physically present there. This is just my opinion. I feel one needs to have a physical internship rather than an online one, because it's just how I would have done things. Not that I ever interned, but it's just how it is. So what are your thoughts?
Well, I think I absolutely agree. There's no substitute for actually being there, and especially litigation. Because litigation, if you're only going to court, only then can you realize. In fact, even the lawyer experience for now, even people who are seasoned advocates, they are also not very happy because advocacy is just speaking your argument is a very, very small fraction of the advocacy that you'll be doing. You look at the others' expressions, you look at what the judge wants to hear. So you must read the room as well. So, that's something that you are obviously missing out when you're doing it online. But I think generally speaking, my views on internship are that please do a variety of them. I've seen that many students, some even would apply to me as a research assistant. They've only worked in 60 chambers, but that do the same thing. I've worked in 60 corporate chambers, which is excellent. You've shown your commitment to corporate law, well done. But you've not really explored anything else. So I think it's important from a career point of view. I think don't think of internship just as a formality that you need to do in order to be able to get a job, which it might be, but think of it as a more holistic development where you're doing it because you genuinely want to learn about the subject and you genuinely want to see if that's what you want to spend the rest of your life doing.
Sir, last question, and I want to ask this question personally. Sir, there are some nuances between the law in statute versus law in practice. So, sir, how can we differentiate them while researching for a legal issue?
I think there are two things that I'd like to say. The first one is the huge lapse that we have in what the statute says versus what actually happens in the courtroom. I've taught CRPC. I've told my students, look, 24 hours, accused must be presented before the magistrate. They go to practice. They call me howling, saying, you lied. This doesn't happen in practice. I say, yes, I'm sorry. This doesn't happen in practice. So I think there's that huge lapse of the statutory, what the statute says versus what happens in practice, because real life there are a number of things that would either vitiate that or sometimes even amplify that. Sometimes the statutes are also not properly connected. So I think law in statute versus law in courts is not necessarily always the same, but more or less, if you read the statutes and if you have a good understanding of them, you can use them when you are into practice. Think of it in this way. Don't think of legal education as a sort of line. Think of it as a foundation. So the statute lays the foundation. Once you get the internship, there's another layer of learning, then another layer, and it progressively builds a tower. So that's what I would say. As they say, the pyramids, have broader bases. So have a broader base, but be uh, be open to things being interpreted differently in practice.
Ma'am, would you like to add something?
I do agree with what Vishwajit just said, but the thing is, I also feel that it's not just progressive. It's not just that, but you need to, at each step, you need to understand as to what you're doing, right? It's very important. And when you're a fresher or if you're a law intern, you don't really think of things like that, because you have nowadays, I'm just now, this is going to sound as if I'm attacking, but then again, I feel that what the way we learned way back when we learned, it was different, and now the way the youngsters are learning, they're not taught the basic etiquette, I feel, as to how to behave in the court or anything. This is what I feel needs to be taught. This is what I feel, apart from the whole statute aspect of things or other things, I feel it is very important that one needs to realize that it's not just that a lawyer needs to have etiquettes, because I always say this, that manners maketh man. Unless you have manners, unless you have the etiquette, you can never really, be a good lawyer. You need to have respect for your seniors. That is very important, and I think this we have learned the hard way. I remember, this is a very small story. I'm going to just wrap it up quickly. I was an intern, I was a law student, and I visited the Supreme Court. I think I was in my second year or something. And I visited the Supreme Court, and I was eating my food. I was eating my lunch in the cafeteria, and I was told by a waiter to get up and move, since it was the lunchtime and the seniors were supposed to sit, right? And I fumbled and I got up and I was like, all right, fine, I should get up. Seniors are supposed to sit. But nowadays, if you go to the Supreme Court canteen and you see there are interns everywhere, and if one asks the intern to get up, they will get all up in your face about it. But the thing is that one needs to learn respect. I mean, I don't say that what happened at that time with me was correct. I'm not saying that. I'm not saying that this is how it should be done. But I feel that when in the courtroom you see a senior person approach, you just get up and leave your chair for them. That's like a basic etiquette of advocacy, which neither the law colleges teach nor the law offices teach. And I try very hard to imbibe that in my interns, but obviously it is from office to office. But I feel respect too is very important in our profession. So I'll just end it at that.
Ma'am and sir, what are your last keynotes to all our participants?
Go ahead.
Right. Mine is, I hope you all found it interesting and got your attendance, because that seems to be a very, very important thing. But I think experiment in law school, be open to criticism. And also the other thing which I would add to what what Dr. Gautam just said was that when you're in law school, I also feel that the current generation, which I think we might be also to blame, is also very scared. They're very scared and they're very nervous and anxious about what's going to happen, whether we're going to get jobs if these times are tough. I see the anxiety, but just stay slightly calm and have the patience, and it will eventually work out. Don't give up so easily. So that's my parting advice to all of you.
Ma'am.
And I'd just like to say, read more books. I mean, that's what I have done in my life. I mean, not that I'm preaching, I'm just I have to nowadays I feel like we continuously have to, calm everybody down because everybody's so angry. But yes, I feel that it is important that we read more books, we educate ourselves better, and the resources and the sources that we use are better than what we had at that point of time. I think we should constantly evolve, is what I feel.
So it looks like we have covered all the things, and it was very nice having you, ma'am. So I would like to call upon Mr. Kushagra, my colleague, to give a vote of thanks. Kushagra?
Am I audible? Aniket, am I audible? Am I audible? Aniket?
Yeah, you're audible. Yeah.
Well, obviously, I would like to thank everyone for joining us. I, Kushagra Nigam, on behalf of the whole team of the Chartered Law Journal, would like to extend a very heavy vote of thanks to both our speakers, Mr. Vishavjeet Chaudhary and Dr. Malika Gautam, for gracing us with their important time and sharing us their expertise on researching skills. I'm sure we all took something out of this webinar which will help us in our moot competitions and writing research papers, etc. Lastly, I would like to thank Rohit Kumar and Siddharth Kumar for all the technical and intellectual support which went on the back end of this webinar to pull off this webinar and also to keep up with the future events of the charter. Please follow us on Instagram and LinkedIn, and also e-certificates will be mailed to all the participants according to the attendance sheet which is being circulated. Thank you very much.
Great. Thank you, everyone. We appreciate you being here. Thanks again for joining us today, and we'll see you next time.
Thank you very much. Have a good day.
Thank you, ma'am. Thank you, ma'am.
Thank you, sir. Thank you, ma'am.
Thank you, sir. Thank you, sir.
All are required to fill up the attendance sheet and feedback forms
Please fill up everything so that I can mail you.
that we can bring enlightening sessions like today's more often. Thank